Okay. Welcome everyone this evening. Thank you for joining us here at our virtual library session. My name is Mariela Colon and I am the unit manager for cultural, civic, and literary engagement at Chicago Public Library. I'm so pleased to offer the latest in our Law at the Library series this evening with attorney Jill O'Brien on topics pertaining specifically to women's issues, being Women's History Month. Throughout her 34 years of practice with Lehner Muschen, Jill's practice has focused on the representation of public and private sector employers in a wide variety of labor relations and employment matters, including collective bargaining negotiations, grievance handling, mediation, and interest arbitration hearings. She also defends employers in employment disputes and labor proceedings in court and before agencies such as the Equal Employment Opportunity Commission, Illinois Department of Human Rights, Illinois Human Rights Commission, Chicago Human Rights Commission, the Illinois Department of Labor, and the National Labor Relations Board. She has in the past served as co-chair of the Chicago Bar Association's Alliance for Women and is one of the top women's lawyers in Chicagoland. We're so pleased she can join us this evening. She will be presenting on women's rights at work, so legal discussion, the first half of the session. If you have questions, please place them in the Q&A button at the bottom of your screen, and we will get to those questions at the conclusion of the program. With that, please welcome Jill O'Brien, and I will turn the floor over to her.
Thank you, Mariela, and thank you to the library and the Chicago Bar Association for allowing me to present today. First of all, happy Women's History Month to everyone who's participating. I'm thrilled to be able to participate in this program as we finish up the month here. As Mariela said, I will be speaking probably about 30 minutes. What I tried to do was put together a slide program of some of the high-level issues that I come across in my day-to-day activities. I do represent employers. Our firm has about 40 attorneys, and that's, our focus is employment and labor, anything to do with the employment relationship. So when we're done here, going through the slides about some of the new developments and some of the hot areas, particularly those that affect women in the workplace, please feel free to talk about any topic, even if I haven't covered it today, kind of a stump the lawyer kind of a program. Okay. I'm going to start with some of the new laws that were enacted in Illinois. So in case you weren't familiar with these, we'll just jump right in here. The first one is the Family Bereavement Leave Act. There has been a law in place in Illinois that allows employees to take time off from work. Not only, a lot of your employers will have handbook policies, or maybe you're subject to a union contract that provides for paid time or unpaid time off to attend a funeral. There also has been a law in place in Illinois that allows you to have additional time off, for bereavement purposes above and beyond attending the funeral. If, after, so it might be months after the death of a family member. The law that had previously existed was referred to as the Child Bereavement Act, and that was to allow employees to take time off to grieve the death of a child later in the year and not necessarily limited to the time of the funeral. That law was since expanded in Illinois so that on January 1st of this year, now employees can take time off not only for the death of a family member, death of a child, but also for the death of a covered family member, which you can see on the slide includes much more than a child. It would also include stepchildren, spouses, domestic partners, siblings, parents, in-laws, mother and father, grandchildren, grandparents, step-parents. You can see that this is a very broadly construed law now so that employees can take time off from work. It is unpaid time off. Of course, the employer may want to go above and beyond and pay for it, but this is really allows an employee to take up to 10 days of unpaid time off later in the year. So for example, everybody will tell you that not everybody grieves alike. So it might be that somebody grieves later in the year, or maybe you want to attend a memorial service for somebody later in the year. What's also new in this, and particularly maybe of interest to women, is that it also allows employees to take 10 days of unpaid bereavement leave following the missed if an employee had a miscarriage or an unsuccessful round of IVF or a failed adoption match or a failed surrogacy agreement, or even for if the employee receives bad news related to trying to become pregnant, or a stillborn child would be something that you can take time off for under this new law. It's intended to be very broadly construed, and you'll see that there's probably many of your employers are expanding their handbooks to include this policy. Another new law that was recently signed just a couple weeks ago by the governor is that effective in January of next year, you may have heard about this in the news, but effective in January of next year, this is a new law that will require all Illinois employers, with some exceptions, to make sure that every employee gets at least 40 hours of paid leave during each calendar year. That paid leave is available, as the name suggests, for any reason. That would be vacation, it could be sick leave, it could be funeral leave, it could be jury duty leave, could be any of our traditional reasons for taking time off. It also might be for attending school plays or school parent-teacher conference or things like that. But the point is, prior to this law being signed, Illinois employers were not required to give any paid time off to their employees. And so it was a matter of, if employees wanted to take time off, they had to use unpaid time off. And now this new law will ensure that all employers give at least 40 hours of paid time off for any reason during each calendar year. I'm going to go through on this slide and talk about some of the key highlights, but it would be employees who are paid on a full-time basis, working generally on a 40-hour work week, would be entitled to this 40 hours of paid leave in a 12-month period. The employees who are, only working a part-time schedule would be allowed to earn a pro rata share of the 40 hours in the year. And the formula for which the time off is earned is that employees earn 1 hour for every 40 hours actually worked. So that would apply to somebody with an irregular schedule or somebody that has maybe a part-time schedule. They would still be entitled to paid time off, although maybe not the full 40 hours in the calendar year. Employers do have a right, once this law is in effect, to grant the time off at the beginning of the year, so they can do what's referred to as front loading the time, so that an employee can start taking the time off at the beginning of the year, or employees can, take it on a pro rata basis throughout the year, and they can earn it pro rata based on the number of hours worked per month or per week, however the employer's policy was defined. The employer is allowed to require employees to serve a 90-day waiting period if they're newly hired, to make sure that employees aren't using their paid time off until after they've satisfied the 90 days. The couple things I wanted to point out is that this 40 hours of paid leave for any reason, it's not in addition to any time that the employer is already providing. So if you are fortunate enough to work for an employer that already gives you paid time off, or maybe you work for a municipality or the state or a public entity that already gives you generous paid time off, that employer is allowed to take credit for that other paid time off towards this 40-hour allotment. So for example, if you're already getting 2 weeks of paid vacation each year, that would certainly satisfy any obligation under this state act. However, the vacation policy that the employer currently has in effect would need to be amended to make it clear that, what this accrual method is 1 hour for every 40 hours worked. They might have to tweak some of their paid sick time or vacation policies, or maybe you work for a company that has a PTO, a paid time off policy. Might have to tweak it so that some of the notice requirements are changed to give employees more flexibility in using their 40 hours of leave. The employer does have a right to require that this paid time off be used in increments of no larger than 2 hours. Many of the vacation policies that I've seen currently might say that your vacation time off has to be used in a full day increment. So for those employers who are trying to use their existing policy to satisfy this new law, when it becomes effective, they would need to make sure that they amend the policy to give the right to use their paid time off in 2-hour intervals. Under this law, employers are required to adopt a policy that asks employees to give at least 7 days of advance notice before using this paid time off. And that 7 days notice would be required if the need to take the leave is foreseeable. But as we all know, there might be a situation where you don't have that advance notice of the need to take a leave. Maybe a family member got sick, maybe you're using it for mental health purposes, or you just need to relax and you don't have a full 7 days notice. If you're using it for vacation purposes, that would be a foreseeable reason, or for surgery, whether it's medically necessary or even elective, the 7 days advance notice would be required if you knew about it. There is no obligation of the employee to find a substitute to cover for them when they're using their time off. A couple other caveats that are listed here is if an employee has not used their full 40 hours of allotted paid time off in the year, they do not get paid, for the unused time, and it would not carry over into the subsequent year if the employer front loads the time so that it's available at the start of the year. But in every calendar year period, the employees would be entitled to at least 40 hours of time off for this purpose. If you are working under the terms of a collective bargaining agreement, a union contract that spells out your terms and conditions, you'll want to check and consult the collective bargaining agreement terms, because the employers and the union have a right to waive rights under this new law and say that the existing rights under a collective bargaining agreement would satisfy anything else that conflicts with that. Another expanded right that's new in Illinois this year, this applies for private sector employers only. It would not apply to those of you who work for municipalities or government employers like the state. But effective January 1 of 2023, employees are entitled to an additional break period whenever they work a 12-hour shift or longer. So if that doesn't apply to you and you're not working a 12-hour shift, then this expanded law doesn't affect you. As to meal breaks, you would be entitled to your normal meal break during each shift that lasts at least 7.5 hours or more. And that is that you're entitled to a minimum break of at least 20 minutes of uninterrupted break period during each shift that lasts 7.5 hours or more. I know I'm giving a lot of information here, and you may find that, you can't take notes as fast as I'm talking. Please feel free to follow up with me after this program, or I'm sure that the program handout will be made available. But you'll also want to consult the posters that your employer may have posted in. Generally, it's in an employee gathering area or a lunch area or a cafeteria room. And the posters do spell out a lot of these same rights. There is, because of the recent changes in the law that I'm talking about that are effective for calendar year 2023, there are some new posters. So you'll want to take a look at those posters and make sure you're familiar with your rights under the law. There's also, under this law, it's ODRISA is the acronym. It's the One Day Rest in 7 Act. And essentially, covered employers under this law are required to provide eligible employees with one 24-hour period in each 7 consecutive day period that has 1 day, 24 hours consecutive where the employee is not working. Now, unfortunately, for those of you who are exempt under the wage and hour laws, and maybe because of the nature of your duties, you're paid on a salaried basis and you have responsibilities such as supervisory or high-level decision-making authority or discretion related to administrative policies, you would be considered exempt under these laws. And so you're not entitled to this 24-hour period of rest, unfortunately, unless your employer went above and beyond the law and decided to adopt that kind of a practice. But prior to January, an employee was entitled to 1 day rest in 7 days, but an employer was allowed to stagger the work week. So it might have been, a 12 or 13 day period before you got your rest, as long as there was at least one 24-hour period in every 7 days. That's no longer the case. Now you look at each 7 day period stands alone for purposes of this law. I'm going to now talk about some oldies and goodies, and that is that there is an Illinois Employee Credit Privacy Act, in addition to federal laws, but essentially Illinois' laws prohibit employers from checking on your credit history. You might have had, the logic is you might have had a medical condition that caused you to file for bankruptcy, or you might have had some trouble with some credit card balance issues. Employers could not use that information in making hiring decision. There are very few exceptions based on the nature of your duties where your credit history would be relevant, and then an employer would be able to ask information during the hiring process. But those exceptions are few and far between. Typically, if you're working for a bank or if you're having access to a large amount of money due to the nature of your job responsibilities, then your employer might find that your credit history is job related. Another law that's been around a couple of years here is that an employer is not authorized to ask you during your interview process what your past employers may have paid you. The logic of this is that employers in the past may have discriminated against an individual based on gender or race or national origin or some other factor. And if the new employer or prospective employer is basing your salary on what you were paid with a prior employer, that might be perpetuating a prior unlawful act or practice of the prior employer. So this way, you don't have to share that information with the prospective employer. A prospective employer is free to ask you if you're in an interview, what are your expectations? What kind of salary would you like to obtain? How much time off would you like to obtain? What kind of expenses would you need to have covered, et cetera? Those kinds of inquiries are perfectly fine to ask about expectations, but they cannot ask you to disclose your actual employment history. There are some exceptions. Again, this particular law would apply for private employers. The expanded rights in 2023 that's also set forth, the ODRISA, that's the one I talked to you about with meal periods and the additional 1 day rest in 7. There are now expanded penalties and also, cash rewards and fines that are imposed against employers who violate those laws. Illinois is very proactive in terms of protecting employee rights to make sure that employees are paid without regard to their gender based on the nature of the work they're performed, their actual job related skills, their employment history, et cetera. There is a relatively new law that was passed last year that is now requiring employers to file a certification if they have 100 or more employees. So if you're working for a large employer, the employer is required to comply with the deadlines and requests that are imposed by the Illinois Department of Labor. And these filing requirements will have to be satisfied by no later than March of 2024. And then there'll be a recertification requirement in 2-year intervals. Essentially, the employer is required to, review their hiring practices and their salary practices to make sure that there is no particular job classification that is having a disparate impact on a particular group. So, for example, making sure that men and women are paid the same with comparable skills and responsibilities. Oops, I went the wrong way on this. Other issues that are important for you to know about in Illinois and also in Chicago and Cook County, there had been certainly some hot topics in equal employment laws right now. And employers are paying closer attention to some of these issues, and particularly those that affect gender and sex characteristics. So, under these ordinances that are currently protected in Chicago and Cook County, and also under the State Human Rights Act, non-conforming employees, including transgender employees, have the right to use the bathroom of their choice. That would include any kind of rest areas that would be needed by employees or available to other employees. That would also mean that the employee has a right to utilize the rest areas and the bathroom facilities of the gender that they identify with. Employees are also, under these various laws and ordinance, free to use their preferred name. as long as it is an appropriate name. And appropriate doesn't mean that you can't use a nickname. It just means it can't be an offensive name or something that would, tend to cause an uncomfortable working environment. But a change that reflects gender or a gender neutral name or is something that is the way that an employee identifies themselves on their email or in a communication, maybe that they're sending communications to customers or to, the media or to the public. Anything that displays their names, they're allowed to use that name, even if it's not something that was the name that they were hired under. And just as somebody would have the right to change their name if they became married, they would also have the right to change their name if it was legally changed. And that would be the same if their name is changed because of the way that they identify. In those situations where employers do require somebody to wear a particular uniform or personal clothes, unless a uniform is required, an employee is permitted to wear clothing that associates with their preferred gender. So just wanted to point that out. These are certainly rights that employees are familiar with now, and employers are certainly making steps to make sure their policies are being expanded to provide for these rights. The laws about 2 years back in Illinois were expanded to specifically cover the pregnancy disability leave rights of individuals. It used to be that pregnancy in and of itself was not considered a disability under the Americans with Disabilities Act and under a lot of the provisions under the Illinois Human Rights Act or the Chicago AEO ordinances. But now the law was expanded to include not only individuals who are pregnant, they're protected under these leave rights, but also individuals who are recovering from childbirth, and then others who may have a common medical condition that's associated with pregnancy or childbirth. That would include the right to take a leave of absence, either on a recurring extended period of time, or it would include the right to take intermittent time off if necessary to attend prenatal appointments, somebody who's receiving IVF treatment and or consulting with doctors for that purpose. These laws are very broadly construed to give the same, quote, reasonable accommodation rights that employees have under the disability right laws that are in effect for individuals who have medical conditions that are unrelated to pregnancy or childbirth or related medical conditions. So for example, if my employer would grant me time off for cancer or a car accident or recovery from a skiing accident, then whatever that policy is, the same rights would need to be extended to an individual who needs time off for medical reasons associated with pregnancy or childbirth. That would also extend to the same rights in terms of recovery following the birth or delivery of a child. The EEOC generally takes the position that the period of disability for an individual following childbirth is generally about 6 weeks, and the period of disability following a cesarean section would normally be 8 weeks. Of course, there is no automatic rule of thumb for everyone. The best advice would be for employers to follow whatever the doctor says. And of course, the employees would be advised to contact their doctors to have it clearly spelled out in writing what their anticipated period of disability would be following the birth of a child if they're seeking leaves of absence for a specific period of time, to make sure that the employer knows this is based on the advice of the employee's healthcare provider. Some rights that I want to make sure you're familiar with that have also expanded in recent years, also in terms of the penalties that are available. If an employee is being terminated, regardless of the reason for termination, it could be termination for cause, it could be termination for voluntary resignation, layoff, COVID, temporary reasons, permanent reasons, regardless of the reason, an employee is entitled to receive their final paycheck, ideally at the time of the separation, if that's possible, if there was advance notice, for example, but in no event later than the employer's next regular payday. So if you get paid every week, that means that the employer has to pay you on the next regular payday, or if you get paid in 2-week intervals or monthly intervals, if you're on a salaried basis, your final paycheck would be due on the next regular pay period. That would include wages and salaries, but it also includes any pro rata share of bonuses that you may have earned, any commission payments that were earned through your last day of work. And in Illinois and California, we are unique in that we require employers to pay out any earned vacation that was accrued by the employee during their employment. So if I was entitled to receive 2 weeks of vacation each year and I didn't use it, I'm entitled to be paid in my final paycheck for my remaining amount of unpaid vacation. Now, that's different than the law we talked about earlier in the program that will go into effect in January of 2024, that is not paid out at termination. But if the employer is using their vacation policy to cover that, then it is not a use it or lose it policy. Vacation is owed out at termination. Under the Illinois laws for payout and in terms of earning and paying out vacation time, an employer does have a right to say in a policy that's in writing and consistently enforced that vacation time is not carried over from year to year. That's fine. That will be enforceable so that an employee has to use up all of their vacation time prior to the end of the year or else it's lost, but that has to be specifically spelled out in the policy. Under another expansion of the wage hour laws, in your final paycheck, you're also entitled to be paid out for any business expenses that you incurred to perform your job. That would certainly include any travel related expenses, maybe for reimbursement of your personal use of the cell phone. It might be reimbursement of your use of your personal car, travel expenses, etc. All of those amounts would need to be paid out in your final paycheck pursuant to the employer's policy. Under the changes in the law, an employer is required to spell out what the terms of the policy would be for when someone has to submit proof or a request that the employer reimburse it for expenses. The general rule is that an employer has to provide at least a 30-day window after the expense was incurred so that the employee can pull together their expenses and submit a request for reimbursement. That is normally what I've seen employers provide in their policies. Is within the next 30 days, you have to submit a request for reimbursement. If you are in a situation where maybe you didn't save the receipt, maybe you're somebody who saves receipts on the phone and it was misplaced, or maybe you didn't retrieve a copy of, an expense from a cab or an Uber, you would be allowed to be within an exception that would allow you to simply give a notice or a statement in writing to the employer that would attest to the fact that, I lost my receipt from my restaurant bill last night when I was traveling. However, I can confirm that the expense charged to my credit card was $50.33. And that would be sufficient to satisfy your notice obligation. In the past, an employer did have a right to ask for actual receipts, and now that actual receipt is not necessary. I'm going to wrap up here until we turn it over to questions. This is probably one of the most common questions that I get from employees and employers, and that is what my rights are to obtain access to the information that's in my personnel file. In Illinois, all employees who are either currently employed by a covered employer, which is 4 or more employees, so either current employees or somebody who was employed at a particular business in the past year, is covered by this Personnel Record Review Act. And therefore, existing employees or employees who were terminated for any reason in the past year have a right to have access to their personnel file. It is quite common for an employee to want to know what documents are in their personnel file, either number one, because they are pursuing a claim or making sure their rights are protected, or number two, maybe it's because they want to know what would be said to a prospective employer in the event that they're looking to apply for another job elsewhere. They want to make sure that they know what's in their file, and they do have certain rights under this law. An employer does have a right to say to the employee, hey, can you put your request in writing? Generally, a simple email request to the HR department would be sufficient to satisfy that requirement. However, some employers do have forms that they use for this purpose before they comply. If an employee submits a request, so if I submit a request to see my file today, my employer has 7 business days to respond, and that would be 7, not business days, it would be working days, 7 working days. So if they're only working 5 days a week, then they would also have 2 days in the following week. If they're a 7-day facility, that would be 7 working days to comply. It does specifically say in this act that there may be a reasonable reason for an extension of that 7-day period for the employer to respond. And that would be, for example, let's say the HR person's out of town or the supervisor's out of town, and they need an additional couple of days to comply. That would be a reasonable extension for 7 days. Under this act, the employees are entitled to any information that was, quote, used or relied on in making an employment decision. So if in fact there's an ongoing investigation and there's no employment decision that was made, that would not be in your file yet because it still was an ongoing investigation and it wouldn't be necessarily required to be in your file. You are entitled to your medical information, and under state and federal laws, employers are required to keep medical information separate from the regular personnel file. That medical information has to be kept in a separate file that's literally under lock and key and limited access, so that only those individuals who have a need to access your medical information, that would be information about yourself or your family members, that only those with a limited need to know have access to that medical information. The logic is I might be your supervisor and I need to pull out from your file information about your last year's review, or how many times have you been warned for attendance, or been warned for the same violation of a work rule. But that doesn't mean that I should have access to medical information about your family members' medical history. So by keeping the medical information separate, that is a way that the employer can help protect your confidentiality rights. And the laws in Illinois and under federal law are very strongly in favor of protecting employee privacy when it comes to medical information. So Mariella, I am going to stop talking now, and I think we can open it up to questions. If we don't have questions, I can come back to the slide program and we can follow up with some of the other hot laws, but I think maybe we can open it up for questions.
We do have a few questions already.
Perfect.
So again, if you are participating and you have a question for Jill, place it in the Q&A function and I'll be able to relay it to her. So the first question, it was early on in the presentation. Will the 40 hours of paid time off be in chunks of a whole week or day at a time? Or could you take 1 hour off or so here and there?
Okay. And under the new law, when it applies in January of 2024, or later if you're subject to a union contract, when that law applies, the employer's policy is going to govern. However, under that policy, it has to say that it can be taken in chunks that are as small as 2 hours. So if I wanted to leave early and go to my kid's soccer game, I could leave early for 2 hours and use 2 of my 40 hours for that purpose. So a lot of times employers will say you have to take it in chunks of 1 full week. That's not required. Now, an employer may grant chunks of 1 full week, but the smallest amount is the 2 hour interval. So hopefully that answers your question.
Another question. I noticed the language focuses on the employer-employee relationship. Does this paid leave policy also cover independent contractors as well? I'll start with that one. It's a multi-part question.
Okay. The laws that are, the law that's covered under this new law, the 1 day, the 40 hours of paid time off does cover employers and employees. It does not cover independent contractors. However, I need to caution you in terms of what phrase we're using for independent contractors, because in my experience, there are a lot of individuals who are misclassified as independent contractors, particularly under Illinois law, which makes it extremely difficult for an employee or an individual rather, to truly meet the standard for being an independent contractor. So even if, historically we've considered independent contractors based on the IRS factors, which generally means that the individual is working independently, they are not paying taxes, they're getting a 1099 form, they're not covered by the business's employee benefits programs. And usually, as long as the employer didn't have, or as long as the business didn't have control over the individual and when they did their work and, those kind of factors, then the individual could meet the standard for being an independent contractor. Those days are over, and Illinois has narrowed the definition, and this law would be enforced by the Illinois Department of Labor. So it is extremely difficult to meet the definition of independent contractor in Illinois, in that you have to meet the fact that, you're not subject to control of the business. But also the most difficult factor to meet, the most difficult prong that I see not being met would be where an individual is involved in a business, and the independent contractor has to be engaged in a business that is separate from the nature of the business that is the primary activity of that employer. So for example, if I am an employer who is a business of operating a public library, if there's an individual who comes in as an independent contractor to possibly replace somebody as a librarian, that person likely won't meet the independent contractor requirement because it's the same nature of the business. However, if they came in as a plumber or somebody who was doing cleaning responsibilities and it wasn't the nature of the business, then that person might meet it. So if you're involved in a completely different business and you are free of control of the business entity, you may meet the independent contractor test. If you truly meet the independent contractor test, then you're not entitled to the 40 hours of paid leave under this law. But if you are labeled as an independent contractor, but you don't meet that test, then you more than likely would be covered under this 40 hours of leave requirement. I'm saying 40 hours of leave, 40 hours of paid leave, meaning paid time off.
And then in addition, are there any industries that are exempt from that policy?
There are industries that are exempt from the policy, primarily railroad industry, construction industry. It's very common in the construction trades for, somebody to only be paid when they're working, and then they might take off periods of time. And also, I don't know if I mentioned it, but employers who have a collective bargaining agreement, a union contract, that has waived this right, they might say that the union contract governs and that would satisfy any other requirement under this new law. Or, as I said, the law generally doesn't apply until January of 2024 or later if the union contract is in place as of the effective date of the law, and maybe you have a union contract that doesn't expire until 2026. If that's the case and there's a contract that governs your employment in place as of the start of the year in 2024, then those rights would not extend to you until expiration of the contract.
Another question. The meal breaks amendment, does that apply to restaurant workers?
Yes, the meal break amendment does apply to restaurant workers. And in fact, there are quite a few additional laws. If you're working in Chicago, there are quite a few additional laws that do give restaurant employees additional rights. That is a program in and of itself, and I'm glad to provide that program another day because I do provide a lot of seminars and I have a lot of clients in the hospitality industry. So if you have questions specific to this, give me a holler after the program or follow up by email, because I'm glad to talk to you about it. But meanwhile, yes, the laws that I was talking about today do extend to individuals in the restaurant industry and hospitality industry. Unless the person is exempt in by the nature of their duties, they are supervisory, etc.
How do employers get medical information about employees?
Employers have a right to ask employees for medical information when there's a business need and a job-related reason to do so. The inquiries that relate to medical information generally arise out of the Americans with Disabilities Act. Maybe somebody's seeking a reasonable accommodation for a disability, or maybe they're exercising their rights under the Family and Medical Leave Act. If an employee is exercising their rights under those laws, the employer does have a right to ask the employee, and frankly require the employee, as a condition of taking and exercising those rights, the employee may be required to submit medical information from a healthcare provider to justify the medical need for the requested accommodation, or the requested time off, or the requested use of sick leave. Employers do have a right to ask for medical proof in some situations, but there has to be, number one, a business need. And there would not be a business need if the employer is simply asking everybody randomly what their medical status is. There are laws that prohibit employers. There's a law referred to as GINA, the Genetic Information Act, which would prohibit an employer from asking you about, your particular medical history or your family member's medical history. Do you have any members that have a cancer history, or, a history of diabetes in your family? Those kinds of inquiries are generally not allowed to be asked by employers. How does an employer get access to information? If an employee is participating in, any kind of sick leave program, FMLA program, leave program, there are rights that an employer has to ask for specific information, but there are also limitations on what can be asked. So I do not need to know necessarily why it is that you're seeking a particular leave of absence, or why you're taking time off under the family bereavement leave. I don't need to know if it's because of a miscarriage, or it's because of IVF treatment, or if it's because of the loss of your sister. I do, however, have a right to ask you to submit medical documentation that you did have, a covered condition. Or a covered event, if it's, maybe it's a miscarriage or some other failed IVF or something of that sort. So I do have a right to proof, but I don't need to know, for example, let's say you're applying for time off to spend time with your mother who is recovering from cancer. I don't need to know the type of cancer. I don't need to know your mother's symptoms. I only need a doctor to say that your mother was incapable of self-care. I don't need to know what the nature of the condition is in most cases. Now, in some situations, depending on the type of disability, there may be an employer business need to have more information about the nature of the condition. For example, it's not enough, let's say that I'm a driver and I have to drive a van or a truck to perform my job duties. Well, in that case, it's not enough to simply have my doctor say that I have a medical condition that gives me a need for time off. That particular situation may be a situation where the employer has a right to say, I want your doctor to confirm that you can meet these essential job functions and drive a car this many hours a day, or operate a van of this size, or qualify for a particular type of license if you need to satisfy any special licensing requirement. So as a general rule, an employer can only ask job-related information. So I can't ask if you can run a marathon. I can't ask if you can stand for 10 minutes a day, unless those are requirements, essential functions of your job. Is there a business need for me to know that information? Because I need to know if you can safely do your job. Then I can ask for that information. So it would be business need and job related. The business need would be satisfied if the employee is asking to exercise certain rights under the leave laws or the sick leave laws, or seeking time off under, maybe it's a funeral leave policy or some other type of policy that would be tied to a medical condition. Beyond that, however, it might be that you're participating in your employer's group health insurance program, or maybe a life insurance program, or some other EAP program or benefit that they're providing to you. In those cases, there is a myriad of laws that would give you certain confidentiality protections and rights not to disclose certain information other than as necessary to the healthcare provider. There are certain rights known as the HIPAA laws that when you're providing information related to, access to or use of your health insurance, that might be a situation, depending on the facts involved, where the employer is not entitled to have access to that information. Generally, however, if it's just enforcing personnel rules, that would be exempt from the HIPAA laws, because I need to know, is this a condition that qualifies for your time off? That might be a situation just for basic personnel file reasons. But again, you have a lot of rights against disclosure of information, and you have a lot of rights to decline sharing information with your employer about medical information. Having said that, if you decline to share information, let's say an employer has a policy that they want you to disclose when you become pregnant, and maybe you don't want to disclose that yet. You want to wait until your second or third trimester before disclosing that. You have a right to refuse to disclose that, but then the employer has a right to say, I don't have enough information to know if you're eligible for time off for that reason. And so you might be giving up certain rights that you have otherwise to take time off because you were unwilling to share that medical information. So you always want to balance your right to confidentiality with, is it worth giving up certain rights you have to participate in employer-sponsored benefit programs? Any other questions?
Yeah. What are the pros and cons of ADR for employees?
So ADR is an acronym for alternate dispute resolution, which basically would mean something like an arbitration clause that would be in a union contract, or an arbitration clause that you may have in your handbook, or maybe a clause that the employer has asked you to sign in your employment contract. I am a very big fan of ADR because I think that it allows parties to explore ways to resolve a dispute other than duking it out through litigation, especially when it comes to employment law cases. Employment law cases are very expensive to defend and very expensive to pursue, and it's time consuming. So if you're really looking to solve a problem, ADR, the pro of that is ADR is normally a faster way to resolve it. You might be able to get somebody to mediate a problem, or you might, and typically that means you would take a retired judge or a retired attorney who would help the parties mediate, and maybe they offer non-binding mediation to help see if there's something where they can broker a deal between what the employee is asking for and what the employer is willing to give, or find some other way to fix a problem. Arbitration is a more formal method of ADR, but it is nonetheless very effective. There are a lot of agencies that offer the services of a formal trained arbitrator that can help to arbitrate, to serve as almost a hearing officer. Again, I'm a big fan of ADR because I think it allows the parties to resolve a problem early. When I first started practicing many, many years ago, ADR was utilized less frequently. And then I would say in the past, 15, 20 years, ADR was utilized more frequently as the workplace laws expanded and the penalties expanded and the number of claims that were filed expanded. It then took longer to resolve a dispute. And if you could submit a dispute to arbitration or mediation, that was a huge benefit to resolving the problem sooner. And to help broker a deal instead of, waiting to have a matter heard in the court system, which might be costly for the employer in the long run. Employment disputes do. I know I've heard statistics that over 90%, and frankly, well over 90% of cases involving employment disputes do settle. For that reason, ADR is a great tool to give the parties kind of a third person who might be a neutral, who can help mediate or broker a deal or arbitrate and hear the facts through a less formal process. ADR is also generally less expensive than the court process itself. The hearings may be shorter. The discovery process is certainly condensed. Discovery means sometimes, depending on the procedures you use, you don't get formal depositions or formal exchange of documents. It might be more of an informal sharing of your exhibits and documents, but it's not a complete, process of deposing every witness in some cases. But again, depending on the forum and depending on the tool that you're using for ADR, there would be more or less discovery and information sharing, more or less length of a hearing. Sometimes the parties will waive closing arguments or briefs or motion processes, which also would cut down on fees and make a dispute process easier to resolve. The downsides are that in more recent year, I've seen some of the, particularly in arbitration of employment disputes or labor disputes, it really isn't as fast. It's not saving as much time as it once did. And for that reason, the parties may be reluctant to utilize arbitration or mediation. I also think that the mediation and arbitration process, at least with respect to employment disputes, is a wonderful method of resolving disputes, because you can get somebody like a mediator or an arbitrator who's focused on and familiar with the employment laws. So that might be, a retired judge or lawyer who is very familiar with the laws, knows the areas of exposure to the employer, knows what a jury is likely to look at if this case did go to full court hearing, knows what the potential penalties are. And I think that that would be much better to go to a mediator, an arbitrator, or some decision maker that is neutral, but also very well versed in the laws, so that they could tell both parties the pros and cons and the risks of their case. That's much better than going to a state court judge that might not be as familiar with all of the ins and outs of the employment laws, because they have to be familiar with all of the different laws. Employment laws also tend to go to federal court if there's, depending on the nature of the dispute. So some people might feel it's less expensive, or, again, it's typically cost that's involved and time to get your dispute resolved earlier through the ADR, but I am a fan.
Great. And we're at the last question, and I think this is going to be sort of a follow-up question. A person is asking, where can they find more information about the narrowed definition of independent contractors?
I'm glad you asked, because I should have mentioned that this is available right on the website, the Illinois Department of Labor website, and there will be a section in the various acts, the Illinois Wage Payment and Collection Act, the Illinois minimum wage laws, the 1-day rest and 7 laws. Those are all available on the Illinois Department of Labor website, and you can pull the statutes. There's also a wonderful link that has the regulations under each of those different laws. There's forms that can be completed if you want to file a claim with one of those agencies. And there is in the statute itself a definition that will specifically define who is an employee. And under the definition of employee, it goes on to say the following are not employees, and it would define independent contractors in the various prongs. One thing I want to point out is the standard under the Illinois Department of Labor, as I said, is different than the standard under the tax laws. It's also different under the standards in the Illinois Unemployment Insurance Act laws. So the definition of independent contractor is going to vary based on the law that applies. So make sure that you're looking at the right definition based on the law that you're trying to see. So for example, if you're looking to see if you have rights under the Unemployment Insurance Act, and you very well may, in my experience, many Illinois business owners do tend to misunderstand the independent contractor analysis, and they might think that because I don't tell that person what time to show up for work, and I don't discipline them, and I don't yell at them when they don't meet their expectations, and I give them a 1099, that's all it takes. And that's not the case. It's a very difficult standard to meet under the unemployment laws, under the tax laws, and particularly under the laws that are enforced by the Illinois Department of Labor. So I would encourage you to look at the Department of Labor website. And I'm referring to the Illinois Department of Labor, but I can tell you all of the administrative agencies in Illinois and frankly, under the federal laws as well, do a really good job of being a good resource just on the internet to find out those basic laws, to have access to a lot of good forms, so that you know what your rights are. There are a lot of FAQs, Q&A type information. And frankly, a lot of that information, not necessarily with the independent contractor analysis, but a lot of that information also is clearly displayed on the posters that your employers are required to hang in every workplace. If your employer does not have their posters hung, do them a favor and all the employees that you work with a favor and encourage them to get those posters hung. The posters are available through a lot of paid resources, but they're also available for free on the websites of these various agencies. If anybody needs a listing of those, if you're an employer or if you're an employee who simply wants to make sure that you're familiar with those posting requirements, you can follow up and email me, and I'm glad to give you any information I can or help point you in the right direction to get that information.
Great. Okay, so we're at the end. I want to thank Attorney Jill O'Brien so much for presenting this really timely and really detailed information to the people who are able to participate today. This session will be recorded and we will be able to disseminate it to all the registrants who might not have been able to join us this evening, and we will share the slideshow and Jill's contact information. If you have any further questions that are of more personal nature, we will be following up and sharing that information with you as well at conclusion of the program. So thank you for all of your great questions. Thank you, Ms. O'Brien, again, for hosting this latest law at the library. Thank you for joining us this evening. Everyone, be well and good evening.
Thank you.